How you doing?
No, where her car?
Whose car?
My lady's car.
Well, we got to figure out because this was reported as unauthorized use. Let's go detain him.
We will have to go to handcuffs. We have to.
Turn around.
These police officers mistakenly believe that this car is stolen, but it's not. They found it parked in front of this building. The 60-something-year-old janitor for that building, he knows who's driving that vehicle. He asked them what they're doing, but then he decides he doesn't want to talk to them anymore. He wants to get back to work. Can those cops forcibly detain, handcuff, and then even tase that janitor, even though the man committed no crime, but just because he has information that the cops want?
Answer the keys real quick. Are those your keys?
These my motherfucking keys.
All right, sir.
You talking about? These my damn keys.
Turn around. Put your hands behind your back now.
So these cops released their own YouTube video claiming that this was completely justified because they had, quote, reasonable suspicion to do this to that man. But I know a few things and I've researched this issue to death. I'll show you why they're wrong. And in fact, they filmed themselves committing a civil rights violation. So police officers in Asheville, North Carolina get this false report from the local Subaru dealership, basically alleging that one of their cars has been stolen. Apparently that turned out not to be true. More on that later. The officers are directed to the car's location via a GPS tracker. One of the officers pulls his gun on the car and holds the car at gunpoint essentially. Fortunately, nobody is inside the car.
Charlie 3 APD, vehicle's clear.
As the officers are standing around with nothing better to do, talking about the car,
I couldn't tell if anybody was in there, so I just went up and cleared it. I didn't see anybody moving in there. This is a nice car, too.
the 63-year-old janitor for this building that they're standing in front of walks up to them and engages with them.
What's up? What's going on?
How you doing?
No, where her car?
Whose car?
My lady's car.
Charlie 3.
Can we come talk to her real quick?
Well, she's work up in Thrive.
In Thrive?
Yeah.
I'll go ahead and point out two things that the cops conveniently ignore in their YouTube video. One of the first things you could notice about this guy, if you looked at him, is that he's wearing his janitorial uniform for this giant building in the background that he's walking from. Janitors usually have keys as well. Secondly, he provides them information that the lady who's driving the car is at Thrive. Now, Asheville's not a huge place. Just a quick Google search reveals that Thrive is a commercial co-working space in Asheville, North Carolina, which just happens to be, from what I can tell, located in the Grove Arcade, which is the building that this guy is the janitor for. Now, just that information right there would have solved their investigation, but they decided to go a different route.
Okay, so who's, well, we got to figure out, because this was reported as unauthorized use.
Reported unauthorized use?
Mm-hmm.
But then he quickly disengages after they start acting like cops are known to act, and he starts to go back to work.
Is that the keys? Let's go detain him.
Oh man, you done this like this?
What? Oh.
Now, they have no reason to believe that this man committed any crime at all, which he did not. Yet, they immediately threaten to handcuff him, and then they use violence on him, pull out a taser, and threaten to use it on him.
You ain't gonna have me lean against the motherfucking thing. Let me go get the lady whose shit that is. You ain't gonna have me lean against shit.
Like, we will have to go to handcuffs. We have to.
Answer the keys real quick. Are those your keys?
These my motherfucking keys.
All right, sir.
You talking about? These my damn keys.
Turn around.
Stop.
Put your hands behind your back now.
Where you at?
Put your hands behind your back.
Body wallet.
Let me go.
Put it. You're gonna get tased.
Let me go for a minute. Hold on.
Put your hands behind your back now. Do it now.
That's the other hand.
Other hand. Let
Now.
your other hand go.
Man, if I don't sue y'all, I ain't
stand up.
on this truth. You good?
Yeah, you're fine.
You good?
Yeah.
How about
Where's that
loosen
key
this
at?
off my arms, man? I'm gonna ask you nice. How about loosen this off my arms?
Here's how it ended according to the most recent media report. Following the investigation, it was determined that Searles was not involved in the vehicle's theft or possession. In fact, it wasn't a theft at all. He was released without any charges and transported downtown at his request. While at the scene, the woman in possession of the vehicle told officers the allegedly stolen vehicle was a rental and that her car was at the dealership being repaired. She said she didn't know anyone inside the Grove Arcade and did not know why Searles would have approached officers about the car. In accordance with Asheville Police Department's standard procedures, the department conducted an administrative review of the incident. The review concluded that the officers acted within agency policy based on reasonable suspicion to detain Searles. Key facts included his familiarity with the vehicle and its owner, his possession of keys potentially related to it, and his lack of cooperation during the investigation. This is from the cops, obviously. Despite media reports to the contrary, Searles did not identify himself as an employee of the Grove Arcade. Was he required to? Did they ask? No. And that's basically the argument that they put in their video. So just to sum things up, no crime actually occurred. Now, everybody loves this guy, apparently. A bystander filmed what was happening. The community was outraged. Then a judge ordered that the body cam footage be released. Now, in their video, the cops claimed that they did nothing wrong because they had reasonable suspicion to detain this gentleman for various reasons. Is that true? They said the officers asked Mr. Searles to stop based on reasonable suspicion to question him further as part of their investigation. That reasonable suspicion was based in part on the fact that Mr. Searles approached the reported stolen vehicle with keys in his hands and that he claimed to know the owner and then walked away from the officers. All right, that is their case for reasonable suspicion. Asheville is in North Carolina. North Carolina is in the Fourth Circuit. There is actually a recent published case out of the Fourth Circuit that dealt with reasonable suspicion. That case is similar to this one. The police were told or believed that a crime had occurred, and they located a nearby individual. They had no information that was particular to that individual that he was involved in any criminal activity, but they knew a crime had occurred and he was nearby. So at the very least, he was a witness, right? And if they want to investigate and they want to detain and question that witness, they should be able to do that, right? According to the cops, according to the Asheville Police Department. Fourth Circuit said absolutely no way. The reasonable suspicion standard, which is a Fourth Amendment constitutional standard, it has to do with suspicion of criminal conduct, not just the cops want to talk to you because investigation. As the court wrote in the opinion, reasonable suspicion to initiate a Terry stop, which is what this is, requires a particularized and objective basis for suspecting that the particular person stopped of criminal activity. Not a witness, criminal activity. The court also made clear that government attempts to spin largely mundane acts into a web of deception don't cut it. Ultimately, the court held that the police officers lacked an objective basis to suspect that Milla specifically engaged in any crime and therefore lacked the requisite particularized basis for the stop. If the officers had no objective basis to suspect that Mr. Searles had engaged in any crime, then they had no right to detain him. They had no reasonable suspicion. The court went on to say that we have explained that nearby exigent circumstances, such as a recent stabbing, or we could use a false report of a car missing from a dealership, do not justify a warrantless seizure of a person unless the seizure is narrowly targeted based on specific information of a known crime in a controlled geographic area. The court pointed out that the U.S. Supreme Court in Illinois versus Wardlow held that stating an individual's mere presence within the vicinity of criminal activity is not enough to support a reasonable, particularized suspicion that the person is committing a crime. But what about the fact that Mr. Searles refused to answer any questions? He refused to comply with the police. He initially engaged with them and then he chose to walk away. He was therefore evasive, and that was suspicious. The officers should have been able to detain him and question him further, right? Let's look at the holding from this Fourth Circuit case, which is controlling, binding case law in Asheville, North Carolina. But Milla's actions were not evasive. At most, they were a decision to ignore the police and go about his business. And refusal to engage with police is not by itself a valid basis for reasonable suspicion. While headlong, unprovoked flight is inherently suspicious, refusal to cooperate or acknowledge the police is not. An individual has a right to ignore police and go about his business when an officer approaches without reasonable suspicion or probable cause. Refusal to cooperate without more does not furnish the minimal level of objective justification needed for a detention or seizure. The fact is that Mr. Searles had every right as a free American citizen to walk away from those cops, to refuse to answer any questions that they asked. They could not force him to be a witness. They could not force him to answer their questions. They had no information indicating that Mr. Searles had committed any crime at all, period. They merely wanted him to answer their questions, which he had already done, by the way. Perhaps if they had been more respectful to him, he may have helped them. But they immediately wanted to detain him, to inconvenience him, to harass him. So while the Asheville police can claim that they had reasonable suspicion because they wanted to talk to him because he had keys in his hand and he said that he knew the woman who had the car, they had no information indicating that Mr. Searles had committed any crime. Just because he may have information that they want, that cannot be reasonable suspicion, according to the binding case law in the Fourth Circuit. So let's review. While the reasonable suspicion standard is not a difficult one for law enforcement to meet, they have to at least allege that the individual they are seizing is involved in some criminal activity. And here is their claimed basis for reasonable suspicion. Number one, familiarity with the vehicle and its owner or driver. Is that illegal? Is that a crime? No. Even if the car was stolen or being used without authorization, would it be a crime to arrest somebody who was familiar with that person? No. Secondly, the fact that he had keys in his hand also was not indicative of a crime. In fact, he told them that those were his keys, and they were in fact his keys. The officers had no indication, other than their own incorrect hunch, that those may have been related to that car whatsoever. And lastly, the fact that he walked away and refused to cooperate. According to binding federal case law, he has every right to do that. That explicitly cannot form the basis for reasonable suspicion. While sometimes it's possible to take completely legal behaviors, such as having keys or being familiar with something or walking away or running away, and tie them together to form some reasonable suspicion that the individual has committed a crime, here they can't do that. In fact, the court has warned that government attempts to spin largely mundane acts into a web of deception are unconstitutional. And here they didn't even put that much effort into it. But let me know in a comment what you think. Do you believe that these cops acted reasonably, just in your opinion? And if you like going through these sorts of cases and also learning the law at the same time, then please subscribe both here and at the blog at thecivilrightslawyer.com. You can also follow me on Twitter at JohnBryanESQ, also the Civil Rights Lawyer there. Remember, our rights don't end where your fear begins. Freedom is scary. Deal with it.